G'day friends and foes, I'm Arjay Martin and this is TINLA episode 23, or Arjay's This Is Not Legal Advice, and nor is it. So in this episode I'm discussing the law in relation to protesting in Queensland for authorised protests. So basically anyone can really protest if they want to try to, challenge the jurisdiction or the validity of certain protest acts or whatever you want to call it. But also there is Speaker's Corner outside Parliament House in Brisbane, where again there's special rights and privileges for people protesting or having political rallies, complaining about things, etc. But besides that, there's also so-called authorised or approved or government-sanctioned protests as well. So the background, I can't get a maroon background for some reason. I'm not used to using this augmented reality emoji thing, but I haven't been able to see anywhere to download maroon to represent Queensland, because then potentially I can do these videos for every state and also territory. So, Victoria is associated with green as an example, New South Wales with blue, Tasmania yellow, whatever. Anyway, so I have applied for an authorised protest recently in relation to the 24th of May 2020, and I do therefore have some experience with this. And also the protest is, well, you can call it separate protest, but separate protests also planned from the 30th onwards, changing the date to Saturday. The previous two protests were on Sundays, and this one that's coming is on Sunday as an authorised protest. And anyway, so I'll say basically what happened with my own authorised protest to begin with, and then I will get into the nitty-gritty of some interesting but important points and the legislation, etc. So basically I applied for a protest to start in King George Square, then go through the Queen Street Mall, and then on to Parliament House. And it turns out that Brisbane City Council does not allow protests in the Queen Street Mall, which again, someone could actually challenge if they really wanted to, but it's simpler not to do that at this stage. So that was the intended route. I then filled out the notice of assembly or notice of intention to hold a public assembly, and that is supposedly to be handwritten. It says that on the top of the form, even though that's a bit even discriminatory it can be for disabled people as an example, but they do have that on the form. So just looking at the form now, it's got a privacy collection statement. It can be addressed to the Commissioner of the Queensland Police Service or the relevant local authority. The relevant local authority is a police station in the district that you are applying in. People can also, as a separate thing, but not trying to overly complicate things, can also go through the courts, but that's another topic or whatever. It's, people will get sick of the videos if they go on for 50 hours. So it has information like name of organiser, name of organisation, address of organiser, contact details for that person, assembly details, including day, date, place, time participants assemble and conclude, and the purpose of the assembly, description of any sound amplification equipment to be used, then it's got if the assembly is to include a procession. So a procession is a rally or, walking down a street with placards as an example, and you can call out stuff like little slogans or whatever if you really want to, if it floats your boat. It also has, do you propose to use roads or footpaths, bike paths? You can actually have cars in a procession, but obviously that would be more strict and harder to get so-called permission or approval, but really, in reality, it is basically a lack of opposition to the protest or assembly. And that is with the standard timing. So normally you would apply at least 5 days before. There are special provisions, again, I won't get into, that you can have a public assembly in less time. That is authorised going through the magistrate's court, but that's too much information for a lot of people. So you write down your proposed route if you want to have a procession, I should say. Any proposed stoppage points, and notice it is proposed because things can change. Then length of time at the stoppage points. Do you propose to carry placards, which are signs, and or banners? If so, supply the details. Are there any special needs groups to be involved with the assembly, e.g. children, people with disabilities, etc.? Details of any vehicles involved. How many marshals are available to manage the movement of the procession. So obviously if you're going to have 500 people and you only have one person in charge, and that's probably not going to be not opposed, because maybe one person can look after 20 people, 30 people, but not 500 by themselves, as a generalization. But anyway, so how will the marshals be identified? E.g., they might have a fluoro vest, something like that. Will marshals be moving with the procession or stationed along the route to be travelled? So you can have so-called static following, or people can just walk along with the crowd, and that's fine too. What is the means of communication between the organiser and the marshals? E.g., mobile phone is a simple one. Voice as well. You could have walkie-talkies and whatnot, but phones are pretty ubiquitous now. So, who will be the person in charge on the day of the event? How is the person able to be contacted by the police? And then also, it has a note down the bottom. The organiser has to sign and date the form as well. But it says, when completed, the original signed copy of the assembly notice is to be sent to the Commissioner of Police, Queensland Police Service, by leaving it at or sending it to a police station in the district in which the assembly is to be held. So for my one, I filled out the form and handed it into a police station in Brisbane near Speaker's Corner, and a couple of blocks away, something like that. And they just accepted it and just said, okay, we'll pass it on to the relevant person. And it was simple. So I assume they must get a lot of authorised assemblies there, because it wasn't like the police officer lady had to ask, what's this, why are you handing me this piece of paper, something like that. Then the other important note is, if it is proposed that the assembly will be held in or pass through a place that is a park, reserve, pedestrian mall, square, or other public place, a copy of the assembly notice is also to be sent to any local authority having jurisdiction in relation to the place by leaving it at or by sending it to the office of the clerk or town clerk of the local authority. So, you can email a copy to the council as an example, and that really is more for a courtesy. The police do liaise with the council and, express their concerns if they have any, or, find out the concerns of the council, that kind of thing, and, that's fine. So basically I put mine in, and a couple of days later I got a phone call from the Queensland Police Service. You just get this private number calling, and the gentleman was very polite and, seems like a nice bloke. And the changes that were made were that instead of going through Queen Street Mall, he explained politely that the council doesn't allow that. So, hey, how about we do it this way? And that's fine, and that's the approved route. And basically, it goes from King George Square up until Adelaide Street, and then turn left into George Street all the way to Parliament. So it's a 1 kilometre walk each direction, and that's reasonable. So of course people can try and argue in court that such notices are constitutionally invalid or whatever, and the requirements to get permission to protest, then that's fine, but I'm just explaining how I've done this public assembly notice. And, I don't really need to go to court unnecessarily to do that. But another interesting thing is basically because the procession was accepted, but with a condition, and I'll get to that at the end, it's a very important one, and ways around it, lawfully and legally, even without, arguing the constitutionality of certain actions and whatever that have been made recently, i.e. in relation to the COVID-19 so-called outbreak or pandemic. But anyway, so as I said, I'll get to that at the end. But basically, if you get approved but with conditions or restrictions, it basically makes it that you can't easily take it to court. Whereas if they do reject it, then you go to the magistrate's court, and there is a conciliation, mediation kind of thing beforehand. That's, to try and resolve things. But if not, you go to court, and then you can argue your case there, which is just the magistrate's court. But anyway, so, and of course, if the magistrate makes a decision that you think is unlawful or unreasonable, you can then appeal it to a higher court. But again, getting too technical. So the most relevant legislation in relation to protesting in Queensland is the Peaceful Assembly Act of 1992. It is 18 sections long. Section 18 relates to regulations that can be made, but there aren't any regulations or subordinate legislation listed on the legislation.qld.gov.au site, so really that part's a bit moot. So going through quickly, you got the short title, it's not so important. The objectives of the Act are to recognise the right of peaceful assembly and to ensure, as far as it is appropriate to do so, that persons may exercise the right to participate in public assemblies, and to ensure that the exercise of the rights to participate in public assemblies is subject only to such restrictions as necessary and reasonable in a democratic society in the interests of 1. Public safety, or 2. Public order, or 3. The protection of rights and freedoms of other persons, and to ensure the right of persons to participate in public assemblies may be exercised without payment of a fee, charge, or other amount for a license, permit, or other authorization. So then it goes on. It also says that basically, yeah, well, let's just skip that part because otherwise it'll go forever. So then it goes on about relationship with other laws, definitions. Section 5 is an important one, right of peaceful assembly. A person has the right to assemble peacefully with others in a public place. The right is subject only to such restrictions as are necessary and reasonable in a democratic society in the interests of public safety or public order, or the protection of the rights and freedoms of other persons. So basically, it is helpful that it does say basically that the purpose of the Act is to prevent restrictions to the peaceful assembly of people, as well as, saying things like the interest of making it free so people don't have to pay fees or whatever for permits. Section 6, legal immunity for participant in public assembly. 1. If a public assembly is an authorised public assembly, so that's one under this Act where you do this process, and is peaceful and is held substantially in accordance with the relevant particulars and any relevant conditions, a person who participates in the assembly does not, merely because of the participation, incur any civil or criminal liability because of the obstruction of a public place. So that gives purported legal immunities, even though, if it's a genuine peaceful protest, you shouldn't be subject to any civil or criminal liability because of that anyway. But it does say about, the obstruction of places, because people can basically hoard around people and prevent them from, leaving an area, which is really unlawful imprisonment. So that's still not allowed. It's still not allowed for people to riot, to do a fray, or have, fights in public, that kind of thing. And of course, it has to be substantially in accordance with the conditions or particulars, and those particulars are based on estimates, though. So, you have to bear that in mind. But obviously, if you say that there's going to be, no megaphone, and you've got 20 people with megaphones and they're just all screaming in it and whatever, then that is against a relevant particular. Section 7, authorised public assembly. A public assembly is an authorised public assembly if notice of intention to hold the assembly has been given under Section 8 and the notice complies with Section 9 and the assembly is taken to have been approved under Section 10. So again, taken to be approved, it's not really permission, even though they use the word permission a couple of times in the Act, and there's, what do they call it officially? There is a so-called notice of permission, but it's not really permission, as I keep arguing. It's more non-opposition to it. So Section 8, giving of assembly notice. So it has to be given to the Commissioner, or if it's going to be held in a place or pass through a particular place, to any local authority having jurisdiction in relation to that place. And you can just hand it in to a police station as an example, or send it to, say, the council or whatever. So, requirements for assembly notice: it has to be in writing, has to be authorised or addressed to the Commissioner or the relevant local authority as the case requires, and be signed by the organiser. So, of course, local authority is also the council as well. But I'll just quickly check that. Doesn't actually define local authority in the definition section. But anyway, so then Section 10, approval of a public assembly. So basically, if you put in this intention of notice of intention, I should say, to hold a public assembly and do it at least 5 business days before the planned protest, then if it's not opposed in that period of time, then it's deemed authorised. The police can also send you a so-called, notice of permission, just to speed things up. But anyway, then Section 11, permission notice may be subject to certain conditions. So they might relate to public safety. So at the moment, we've got these so-called public health directions. So, they can say that people should be 1.5 meters away from each other. Even though those directions are invalid, I submit, completely invalid. But then, as the police officer said, because they're trying to gauge, how ridiculous you're going to be, or if you're doing a legitimate protest kind of thing. But then, as he stated, that's a matter for the court. Then there can be an application for refusal to authorise a public assembly. So again, it goes on about 5 days, and the relevant authority may apply to the Magistrates Court for an order to refuse it. The court must take into consideration certain things, of course, and the court may order to refuse or authorise the holding of the public assembly, or specify conditions that are to apply to the holding of the public assembly. And 13, restrictions affecting application for refusal to authorise public assembly. So like I said, basically if they do approve it but put conditions on the approval, it's a lot harder to challenge that than if they just outright refuse it and then you go to court. Then Section 14, application to authorise public assembly. So someone can, apply to the court if they do refuse it, as an example, or if it's less than 5 business days, to get approval of the court. Section 15 is about restrictions. And that prohibits you from, in subsection 1, I'll read it. So it's restrictions affecting application to authorise public assembly. Subsection 1, the organiser of a public assembly is not entitled to apply for an order under Section 14, which is to an application to authorise public assembly, if the relevant authority or each relevant authority, as the case requires, has notified the organiser in writing that the relevant authority does not oppose the holding of the assembly. Then 16 is about the hearing and determination of applications. 17, limitation on delegation. So the police commissioner can delegate their decision-making ability on, authorising or not opposing a public assembly, but it can only be done to a police officer who is at least the rank of sergeant or higher. So, or at least that of a sergeant. You also have, importantly, within the criminal code, the closest relevant section, just quickly looking, would be in Chapter 9, breaches of the peace, Section 61, riot. If 12 or more people who are present together, assembled persons, use or threaten to use unlawful violence to a person or property for a common purpose, and the conduct of them taken together would cause a person in the vicinity to reasonably fear for the person's personal safety, each of the assembled persons commits the crime of taking part in a riot. So they can have, 7 years imprisonment, 3 years imprisonment, different parts for different circumstances. But of course, no one wants no one to do with me at least, is trying to get a riot to occur, and anyone who is behaving poorly, behaving violently or whatever, then organisers can just tell the police who will be present and say, hey look, so and so just said XYZ, and then it's up to the police officer to make their own determination if they will, remove that person. It has to be reasonable, of course, but it is better to do it that way than to say, hey, look, get rid of that person directly, because that might well have certain implications. Possibly malicious prosecution or defamation actions if, just say, you misquote what the person said. So, just let the police sort it out. Also, within the Police Powers and Responsibilities Act, it has various sections on protests. Sorry about that. So, Section 53 double B, what is an out of control event? So, may as well just read it. An event becomes an out of control event if 12 or more persons are gathered at a place, an event, and 3 or more persons associated with the event engage in out of control conduct at or near the event, and the out of control conduct would cause a person at or near the event to reasonably fear violence to a person or damage to property, or to reasonably believe a person would suffer substantial interference with their rights and freedoms or peaceful passage through or enjoyment of a public place. So again, if people be jerks, tell the police to, investigate. Subsection 2 goes on to say that the following are not out of control events: a licensed event, a major event, an event that is primarily for the purposes of political advocacy, protest, or industrial action. So that's very important, and that means that section does not apply. But if someone, how can I put it? So as another example, some people are suggesting you don't protest, you only exercise, whereas when I made my video about 2 months ago now, suggesting that people could exercise whilst protesting, that can give you further protections. And some of them I'm not even going to list in here, but if you deny that something is a protest or political advocacy event or industrial action, whatever way you want to call it, then someone could imply or say that you are admitting that it wasn't a protest, and therefore Section 53 double B does actually apply. Anyway, so I think it's a bad idea to not say, hey look, I'm sure I'm protesting, but I'm exercising, I'm allowed to exercise, if that's the way you want to do it, instead of just plainly protesting. Also, just wait a second, just quickly checking something. Oh no, that's correct. Anyway, also Part 5, which is directions to move on within the Police Powers and Responsibilities Act. This is basically already covered in TINLA episode 21, but again, there's only certain reasons why police can actually move you on, and again, an authorised public assembly under the Peaceful Assemblies Act 1992, move on orders don't apply to that. So that's in section 45, which is entitled part does not apply to authorised public assemblies. Sorry, my voice is going squeaky. I've been speaking all day. Anyway, so with the directions to move on, as discussed in episode 21, basically there has to be certain reasons, such as people causing anxiety to a person entering at or leaving a place, that, it has to be reasonable in the circumstances. You can't just have some person being a nutcase or claiming that they're got anxiety for no reason, that kind of thing, based on the actions of the people. Interfering with business or trade unnecessarily, obstructing, hindering or impeding someone entering, leaving or at a place. This is paraphrased, by the way. Disorderly, indecent, offensive or threatening to someone entering or at a place or leaving a place. Disrupting the peaceful and orderly conduct of any event, entertainment or gathering at the place. So that last one is important, because if you are having a protest, which is peaceful or peaceable as they call it, and orderly, then if someone's interfering with that event, they can be moved on by the police. And again, you can, go to the police and say, hey, look, we're having a peaceful protest. It's an authorised protest is even better. Or if it is at Speaker's Corner, and, that person over there is threatening our people or something like that. So can you move them on? And also, there can be other charges as well, such as assault and whatnot. There's also another funny little part, which is subsection 5, and that relates to if the police reasonably suspect that because of a person's behaviour that the person is soliciting for prostitution. So if you're not prostituting yourself, so to speak, which a lot of people will argue that the politicians are prostitutes for the lobbyists and, big business, that kind of thing, and that's fine, but obviously they actually mean, hey, give me $50 for whatever, or $100. I don't know what prices are because I don't do that. So basically, the police can't move you on unlawfully, and, with the authorised protest for Queensland, then if people are behaving themselves, then no one can be moved on. And, you're following the substantively following the outline of the protest. If you say that, hey, look, we're going to be protesting at King George Square and going to Parliament House via Adelaide Street, then if you instead meet up at the big Ferris wheel and protest at the little lagoon at South Bank, then obviously that's no longer an authorised protest. Sure, it's still a protest, but then you don't have these additional protections. So, importantly, I will talk about a particular restriction. So, the police originally suggested that, or they asked, do you intend on having people socially distanced 1.5 metres roughly apart? And then, of course, I said, sure. And if you actually read the directions, it says something like, we're reasonably practical. So obviously, if there's millions of people turn up, then that's a different story. But I also pointed out the invalidity, I should say, of the public health directions, and for particular reasons, not even going into constitutional arguments, but, I'm sure the police officer, does care about rights and stuff like that, but then if he hears it from many people, then he might well look into it and find out that, these directions and fines have been unlawfully given, which I submit, and that's why it was important for me to bring that up. Then also the original suggestion was that there can't be groups of more than 10, but that there could be, multiple groups of 10 that would have, say 2 meters gap between each group of 10. And then later on, a police officer recalled back and had clarified that that would not be permitted under the current health directions of Dr. Jeanette Young. And anyway, so cutting a long story short, there's probably 4 or 5 phone calls, and this is very important, especially for other people, intending on holding protests. You can actually apply through the Department of Health's website for an exemption from the COVID-19 restrictions, i.e. the lockdown. So I have also done that. I've still not heard back from the, basically the decision is supposed to be made by the Chief Health Officer or Chief Medical Officer, i.e. Dr. Jeanette Young, but I've not heard from her or her delegate if she is even allowed to delegate that power. But, I pointed out that the purpose of the protest includes protesting against the unlawful lockdown. And also, what else? So I do have a whole list of things, about 13 things on the Reset Parliament webpage or events page for Arjay Martin's For Australians on Facebook, but not all of them obviously could fit, and some were summarised. So basically, what my protest is about, it includes things like being against the unlawful lockdown, against compulsive medications, against, certain restrictions within the lockdown in particular, against a bunch of other things, unsafe technologies being rolled out as another example. But it also includes things like, we need to restore the upper house of Parliament, to restore checks and balances within the Queensland government. Basically, in 1917, there was a referendum which was to abolish the upper house of Parliament, and for Queensland that is, and it failed miserably. But then the Labor government just inserted more people in the upper house, the Legislative Council. Back then, people were appointed as opposed to elected for the upper houses of some parliaments. And then those people voted for the abolition of the upper house against the will of the people, which again is, has a number of problems with it. One, it is a defining characteristic of the Westminster system that you have bicameral parliament or two-chambered parliaments, and currently the Northern Territory, ACT and Queensland don't have that. So, that really should change. Another one is that they went directly against the will of the people. They are supposed to be representatives, not dictators, as another example. And anyway, so if you're intending on doing any protesting in Queensland, I would suggest, and this is not legal advice, but I suggest personally that you fill out your application as it says in handwriting, which a suggestion is that that requirement be removed as well, because, anti-discrimination laws, that kind of thing. How's a blind person supposed to organise a protest, as an example? Especially we have, human rights acts and anti-discrimination legislation at the state level as well as federal level. Anyway, so put your application in. Also apply for an exemption against these ridiculous but illegal, I submit, COVID-19 lockdown restrictions, so that the condition isn't that you have 10 people only, but, who knows how many people are going to turn up. I used to have monthly meetings, and sometimes you'll get 30 people saying they were going to turn up to something as going as opposed to interested, and you might get 6, 7, 8, 9, 10 people turn up. So it's not even a good indication as to the events page, say on Facebook, and that's my suggestion. Please like, share, subscribe, and feel free and encouraged to donate some money to me at paypal.me/Arjay Martin, so that I can put out more videos and more interesting videos covering topics. I do have a focus on law, obviously, but covering topics that may well benefit you as a person. I'll also perhaps make similar videos to this for the different states and territories. Otherwise, I can just, suggest that people watch this video, learn from this video, then find your state or territory's equivalent laws and follow those. So, for instance, in New South Wales, there's a 7-day notice requirement for authorised protest, just as another example. And also in Sydney, as another example, they also have a speaker's corner, which is in the Domain, which is a big park in Sydney. Anyway, thanks for your time. Please get this message out, because the more people that watch it, the more people are helped. The more people can watch a simple video rather than try and do all this research themselves, which, if something particularly affects you, then sure, do the extra research, but this is a good starting point for that anyway. So, thank you and cheerio.